I aced my quiz and I'm super proud of that. If you haven't seen my previous videos, I did a full-on predictions video on what I thought the outcome of the Rule 59 motion would be based off of the research and notes I had taken. But then I also had the immense privilege of being present at the hearing today and hearing the arguments made in person, which was chef's kiss. So I'll be doing a full recap, not just of the legal arguments and the motions, but also what I witnessed, what I saw, what I heard, what I thought, all my notes. I'm going to be looking at this for quite some time. I'm also going to be sharing some of what the motions look like so that you have a refresher of what was argued in writing versus what was argued orally. I'm enjoying my new disclaimer, which is that I am a certified law nerd and a bona fide non-attorney. I just like to research this stuff. I find it super interesting, and I've really enjoyed breaking down a lot of these motions and everything that's going on in the court record. So I hope you continue to enjoy this with me, and if you're not following me, follow me. Oh my God. Real quick, before we even entered the courtroom, I had the immense pleasure of meeting 3 members of the Boots on the Ground team, Black Goddess, Glomo, and Tatted. They all have such a beautiful, warm, grounded, nurturing energy. It was really, truly a pleasure to spend time with them, and so I just wanted to give them a quick shout out. I did see Brenay and Tim in the courtroom, but I just caught brief glances. If I'm honest, I kind of kept my head down and focused on taking notes. I let the rest of the Boots on the Ground team do what they do best, which is record footage for y'all and observe and give you their observations. So I really stuck to the legal arguments. But with that said, let us begin, because it was only 45 minutes, but a lot happened in those 45 minutes. First off, this was a combined hearing where they were discussing multiple motions. The first being the Rule 59 motion, the second being the motion to quash for Brenay's former attorney, Attorney McDavid, and then 2 motions for sanctions. Right away, the court warned us absolutely no cell phones, no recording. They see a cell phone out, it was being confiscated. The first issue that was discussed was actually the motion to quash, and that one was pretty quick. He was not present and he was not available to testify, and so a subpoena was never reissued for him. He wasn't there. So essentially, both attorneys agreed there's nothing to argue because he wasn't present anyway. So that was dismissed. Next, we moved on to the Rule 59 motion, and just a quick human observation, Attorney Hamilton made these arguments on behalf of Brenay. She's very soft-spoken, very elegant, and very clear. I enjoyed listening to her. The judge was very clear. I've already read the motion, the response, the affidavits. I've got all the information in writing, so keep it succinct because I just want to hear your oral arguments. With that said, I'm going to show you the motion so that you can compare what was said versus what was written. So the first argument was for excessive damages. She began by focusing on the verdict form. Her position was that the verdict form did not separate nominal damages from actual damages, and because of that, it's impossible to determine what justified the amount awarded. She did, however, acknowledge that the civil verdict forms often don't break damages down that way, but argued that it was still problematic here. She then cited and argued a case that is not in the original motion, and I had to take it away and do some research on it before I made this video because it wasn't mentioned at all in the original motion. She cited Worthington versus Bynum, a 1989 case. She explained that in that case, a drunk driver had plowed into some plaintiffs, and then when the damages were awarded, the judgment was entered against the drunk driver, the judge determined that a jury award was excessive and stepped in. Now, sitting there listening, my immediate thought was that this sounded like a personal injury case, and if I'm not mistaken, Attorney Hamilton is a personal injury lawyer, so it tracks that she would reference a case in that realm that she's familiar with. But in my opinion, and this was my thought in real time, it felt like we were comparing apples to oranges. Alienation of affection and criminal conversation are intentional torts. They involve willful and malicious conduct. Personal injury cases are typically negligence-based, so that distinction is pretty important. At one point, she said that the damages felt like punishment, and I literally wrote in my notes, duh, because yes, that's the point. These torts are meant to punish intentional wrongdoing. She also argued that Akira was the supporting spouse and Tim was the dependent spouse during their marriage, and that when you try to calculate actual damages, the numbers don't make sense. Then she moved on to insufficient evidence to justify the verdict. She brought up the prior affair and argued there wasn't enough evidence that the marriage had truly reconciled afterward. She also mentioned that this was a young marriage, implying that it wasn't firmly established. This is where she quoted testimony from day 1 of the trial, specifically pages 138 through 142. She claimed 139, but full context is on pages 138 through 142 of the transcript. Her argument was that Akira made a statement on the stand suggesting she had given everything to Tim and later discovered it was all a lie. but listening in court and having reviewed that transcript, thanks to the videos we've done together, that testimony was taken completely out of context. Akira was not referring to Tim, she was referring to Brenay lying to her as a friend. Attorney Hamilton argued that this one statement should override what she called the scintilla of other evidence. And I'm just going to translate that real quick for those who may not know what that word means. A scintilla just means a tiny spark of evidence, like the smallest possible amount. What she was saying is that that one statement, which again was taken out of context, should outweigh everything else the jury heard because it establishes that Akira knew that Tim wasn't truly in love. Her final argument was that Brenay was pro se and that managing all of this without a lawyer was inherently unfair. This is where the judge stepped in. He reminded counsel that Attorney McDavid withdrew with Brenay's consent, and then he made an important comment, in my opinion. He said, in his opinion, Brenay actually did a pretty decent job of defending herself. He did not list motions or objections, but he simply noted that under the circumstances, she handled herself competently. Attorney Hamilton then relied on Rule 59, subsection 9, the catch-all, to make this argument, and the judge asked a very direct question. Is there a recognized legal reason that allows me to exercise discretion here? And her response was she couldn't find one. The argument ultimately came down to fairness, and feeling unfair is not the same thing as meeting the Rule 59 standard. Then it was Attorney Robbins' turn, and her tone was a bit different in my opinion. It was louder, more authoritative, still clear and elegant, but again, more authoritative in nature. Before she even began, the judge told her to make it quick, because he had already read everything, and in the room, it felt like the analysis had already been done. I'm going to be honest, I feel like all of us kind of got the message here. He has already reached a decision, and so she didn't need to break down her arguments too much. He wasn't telling her to hurry up and because he was over it. It was more so, I don't need full recaps type thing because I've heard what I needed to hear. She emphasized that Attorney McDavid withdrew in October 2024, and the trial didn't begin until November 2025. So there was over a year to retain new counsel. She said if Brenay was truly scrambling, we would have seen more effort, but that's not what we saw. We saw an average of maybe one new attorney per month that was sought out, right? Not that was hired, but that was sought out. She also mentioned that there was no new motion for continuance. The court warned her the case would move forward, and she agreed to proceed. She then pointed out that the testimony quoted by the defense was taken out of context, and she emphasized the volume of evidence, hundreds of exhibits, plenty for a jury to decide. And she argued that this motion was an attempt to delay enforcement of the verdict. I do want to note one thing. I want to circle back. She pointed that the reason that this testimony was taken out of context is because this attorney was not present during the trial. And so relying solely on the court record and transcripts points to a glaring problem here in not truly understanding what was being said. As soon as these arguments were over, the judge surprised me because I don't see this often based off of the trials that I watch. The judge ruled immediately from the bench, a bench ruling. The Rule 59 motion was denied. No new trial, and then he immediately moved straight into sanctions. Attorney Robin argued that the motion was frivolous, and here the judge disagreed. He dismissed the sanctions motion, stating that he did not believe the Rule 59 motion was frivolous. For those who don't know what that means baseless. Mind you, the attorney has every right to make the legal argument, but the judge may agree or not agree. Just because an argument is weak doesn't necessarily mean that it doesn't have legal basis, and that's just a discretion that a judge makes on a case-by-case basis. So it wasn't really anybody did anything wrong. I just happen to disagree that this is a sanctionable motion. Then the second motion was for amended sanctions for unpaid attorney fees, and that was dismissed as moot because the fees had later been paid. Now, forgive me if I blew through that. As you can tell, I am starting to catch something and I'm like sneezing, so I'm having to pause a lot. So I'm trying to like breeze through it before my throat gets itchy and all that yuckiness starts. What's next? Well, the motion for the new trial, done. That phase of this process is complete. If Brenay wants to continue, the only option is appeal. But I do need to state that appeals are extremely expensive. This is a long, drawn-out process. This case would then go before the appeals court. You have to be able to find legal grounds. You need to find legal error. We are not reviewing evidence at that point. This is a different ballgame. So without legal standing, the appellate court can technically just deny the motion without even hearing it. So it is a much longer process. For those who will ask what happens with the writ of execution and with collecting the judgment, none of that changes. Literally nothing. As soon as the appeals process starts, she would have to post a bond if she wants that collection effort to stop. Otherwise, it can continue as long as it takes to get to appeals. And mind you, appellate briefings, finding an attorney, all of this is very long and lengthy. That process can take up to 18 months. So this hearing aligned with what I expected procedurally. I'm very excited. The judge had clearly done his analysis before walking into the courtroom. He gave both sides the opportunity to be heard, and I think that he did that very respectfully. But he made his decision right then and there. He didn't hear anything argued orally that would change his mind, which is why he was able to issue a bench ruling. But yeah, thank you for listening. Thank you for allowing me the space to kind of be a law nerd for you guys. I do it with the utmost respect. I do it with a lot of care for y'all, and so I'm glad that you're enjoying it so far, and I hope to continue to do it on this case and other cases. Catch you in the next one.